So hello everyone, myself Advocate Gautam Harshwal working with LEXIS and Company Law Firm as a junior associate. So today in this basically in this video we are going to discuss the remaining part of what are the laws in India regarding bail. As we have discussed, this brief of what are the laws in India of bail in the first part of this video of first part, but in this video this is the second part of that video. So in this video we are going to basically complete our discussion regarding what are the laws in India. Let's start our discussion without further delay. So as we have discussed in under which section, bail in India under CRPC force, which is section 438 of the CRPC. If you have not watched that video, go ahead on the channel, go and watch it. Let's start our discussion. So further in there are so many types of offences in India, right? There are basically two types of offences. The first is bailable offence and the second is non-bailable offence. If you are a law student and you have read CRPC subject, you must have heard about these two terms. What is bailable offence and what is non-bailable offence? If you don't know, let me brief it to you. Bailable offences are those offences basically where getting bail is a right of the accused, right? No judge or police officer can deny your bail if the offence that you are charged with is bailable, right? So that is what bailable offence. So what is and so let's discuss non-bailable offences. Non-bailable offences are those offences where bail is not a right of the accused person, but if it depends on the discretion of the judge, right? So how we can identify bailable or non-bailable offences? How we can, as an individual person or a citizen of India, a non-law background student or person, can find out what is the difference between the bailable offence and non-bailable offence. But check the under which the offence has been applied to you. For example, under every section in Indian Penal Code, it is mentioned whether the offence is bailable or non-bailable. If the offence is bailable, then you will get bail easily. But if the offence is non-bailable, then you can either apply for anticipatory bail or normal bail, depending upon whether the person is arrested or not. So that's what all about non-bailable offence. Further in this video, we are going to discuss what is anticipatory bail. So what is anticipatory bail? Anticipatory bail is if a person is not arrested, but there are chances that he can be arrested, he can file for anticipatory bail under section 438 of CRPC. And an anticipatory bail will be filed under a session court and not under a magistrate, right? And it can only be filed if the person is not arrested. The court checks three things while deciding on an application for anticipatory bail. The first is reputation. Will the arrest harm your reputation or not? Second, is the offence against you is valid or not? The third thing, will you appear before the court or investigation authority when required? So these are the basic things. Only then, if you fulfill these three conditions, only that person can be granted anticipatory bail. Otherwise, if you do not fill a single condition from these three, you will not be granted anticipatory bail. Okay. So after considering these factors, the judge decides whether to give the anticipatory bail or not. If the bail is given, then you can use the certified anticipatory bail if a police officer comes to arrest you, right? So it's basically you are going to get a document from which you can prevent police officers to arrest you. Okay. So the next question would be in your mind is, can you get anticipatory bail before any FIR is registered against you? So this is a very confusing question. So it is not necessary that an FIR must be registered for you to file an anticipatory bail. If you feel like there will be an FIR registered against you, registered for which you can be arrested, then you can file for anticipatory bail as a precautionary measure, right? How it's precautionary measure? Because it will give you safety or protection from getting arrested, right? Before you being arrested. You can get a certified copy of your FIR from the magistrate court, or can find it on your state's online portal. From there, you can download your FIR. Then you need to file a bail application in a session court. So, what is the validity of anticipatory bail? Right? In a recent judgment of Susila Agarwal versus State of NCT of Delhi, it's a case of 2020. The Supreme Court gave a judgment that anticipatory bail will be valid until the trial is over. That means your arrest depends solely on the decision of your trial, right? And if you are convicted, then you will be arrested, and if you set free, then there will be no more requirement of bail. Although some of the acts and states have no provision for anticipatory bails, like the scheduled castes and scheduled tribes. Prevention of atrocity in 1989. It is such a basically it is a kind of sort of dangerous act as well for some people, and it's a very controversial act as well. We can discuss this in another video. Let me know in the comment section should we discuss or not. So that's all about bails are in India. This is the second part and the final part as we have discussed. So, what is your opinion regarding this? What is your opinion regarding the laws regarding bail in India? If you have any suggestion, let me know in the comment section. If you have any query related to this, do comment, share this video with your friends. See you in the next video. Bye bye.